You're here today for a hearing on a petition for injunction for protection against domestic violence, dating violence, repeat violence, sexual violence, or stalking.
It's important that you listen closely to the information in this video presentation. It will help you better understand the process and your involvement in these proceedings.
An injunction is a court order that prevents one person from coming in contact with and committing acts of violence against another person. The law says that anyone may file a petition for an injunction if they're the victim of domestic violence, dating violence, repeat violence, sexual violence, or stalking, or if they have reasonable cause to believe that they're in danger of becoming the victim of domestic violence or dating violence. For the purposes of these proceedings, if you file the petition for injunction, then you are the petitioner in this hearing. If you've been served an injunction or order setting hearing by law enforcement, then you are the respondent in this hearing.
In each case before the court today, a sworn petition was filed stating that the petitioner has been or fears that they will become a victim of violence or stalking by the respondent. Based solely upon the petitioner's sworn statements, a temporary injunction or an order setting hearing was entered by the court and served on the respondent by a law enforcement officer. Please be aware that this is a civil hearing, not a criminal hearing. This case is completely separate from any criminal case already filed or filed in the future. As a respondent, if an injunction is issued against you, it will not result in a criminal record.
All rise. Court come to order. Fair that both parties stand. Raise your right hands and be sworn by the clerk.
Do you swear or affirm the testimony about to give shall be the truth, the whole truth, and nothing but truth, so help you God?
The purpose of the hearing today is to have both sides present to determine if the petitioner still wants a final injunction for protection and if the respondent agrees or disagrees with that injunction. Questions will be asked of both of the parties. Please answer all questions politely. Do not interrupt each other, do not interrupt the judge, and do not interrupt anyone else in the courtroom. This is not television court. People do not yell and argue here. Everyone waits their turn to speak to the judge, speaks only to the judge, and listens to the judge and to each other.
Once again, today's hearing is a civil matter. However, the allegations in this matter could result in criminal prosecution and could be used against you in a pending or future criminal proceeding. Please keep in mind that everything that is being said today is being recorded. The State Attorney's Office regularly reviews these recordings and may use anything you say here in a criminal prosecution against you. You do have a right to remain silent in this proceeding if you wish to avoid making incriminating statements. If a final injunction is issued, a respondent may be ordered to do or not to do certain things. Also, if a final injunction is granted and then violated by the respondent, it can be a criminal offense. If a final injunction is granted, all parties should read the injunction and must comply with its terms. Additionally, the spirit of the injunction is that all parties should avoid and refrain from any conduct which is intended to harass, annoy, embarrass, or inflame the other party. If accidental contact occurs, each party should just go their own way. Also, if an injunction is granted, the respondent will not be permitted to carry or possess a firearm or ammunition while the injunction is in place.
While a respondent may not agree with what a petitioner has stated in the petition, the respondent may have no problem staying away from the petitioner and having an injunction in place. If this is the case, then the injunction will be entered by agreement. If you have children with the other party, then we will address contact with the children, child support, and other issues at that time. If a respondent does not agree to the injunction being granted, then a full evidentiary hearing will take place. Both parties will be allowed to present evidence. The petitioner will be asked to testify first about the most recent act or threat of violence, harassment, or stalking. Petitioners, please begin with what led to the filing of your petition for an injunction and include the exact or approximate time, date, and place where the event occurred. The court does not need to hear long explanations from either side. Both parties may have information that they want the judge to hear. However, the judge may not hear all of it. The judge decides what information is relevant. Once again, the court will address contact with the children, child support, and other issues that are related to the safety of the parties.
Once the final order is completed, you must wait until you receive your paperwork from the deputies before you leave, and you must follow the deputies' directions. Whether or not a final injunction is entered, the judge will place time and distance between the parties. If circumstances change in the future, either party may request that any final injunction be dissolved or modified by the filing of a motion with the court. If a respondent does or says something that violates the injunction, then the petitioner has the right to request in writing that the injunction be extended for a longer period of time.
When a final injunction is granted, certain respondents will be ordered to attend a batterer's intervention program. The law requires the court to order a respondent to attend such a program if the respondent willfully violated the temporary injunction, or the respondent has been convicted or had adjudication withheld for a crime of violence, or if the respondent has had a final injunction granted against him or her in the past.
If you are ordered to attend batterer's intervention, the court will set a separate status hearing which you must attend in person to provide proof of enrollment. At this point, it is critical that you stay in the waiting room so that you will not miss your case when it is called.
Thank you for your attention to these instructions.